Good morning, everybody. Hopefully you can all hear me. Can somebody give me a...
Yes, good morning.
Yes, excellent. Thank you very much, whoever that was. I'm Kevin Duffy, as you all know, from the Scottish Engineering Legal and HR team, and this is the June breakfast briefing. It's not me presenting it today, I'm just the initial host. Today we have John Lee, one of the partners in employment law from one of our Ledingham Chalmers LLP, who is an organisation we have had a long history with and partnership with. And he's going to be giving a very interesting talk on recent changes on immigration law. As is always the case with the breakfast briefings, it's currently being recorded, and John will be putting up some slides which I will send out along with the link to the recording later on to participants. So without any further ado, I can let John give his presentation, and we'll take a short few minutes at the end just for a Q&A session. So John, over to your good self.
Right, thanks, Kevin. I'm just setting a wee timer because I know everybody will want to get back to their desks and their screens and workplaces and so on. I'm just going to share my slides, hopefully. There we go. Right. Can everyone see the slides? Yeah, Kevin, can you confirm that for me?
Yep, that's good. Thanks very much, John.
And I should be able to whiz through. So thanks for that introduction, Kevin. Kevin set the bar quite high this morning with immigration law by telling you I'm going to make this very interesting for you. I will do my very best to take you through what has happened recently, and I'll do my best to make that very interesting. Just a wee bit about the firm first, if I may. We are full service, as Kevin said. We've a partnership with Scottish Engineering, in particular for Scottish Engineering members, which entitles you to a free first consultation and 15% off our fees if we're ever called upon to help you, and that can be across any disciplines that you need assistance with, mainly commercial property issues, corporate litigation perhaps, and so on. So that's a wee bit about the firm, and you can see our credentials on the slide. I won't dwell on that. I'm formerly of Scottish Engineering myself, which is where the connection comes from, having been involved with many member companies over quite a number of years, some time ago. Anyway, on to the topics this morning. The government has introduced changes to immigration law with effect from April. The announcement was March. The changes came into effect in April. Some of them have been delayed slightly, taking effect from August. Most of them are in force now with effect from actually the 30th of May, if I remember correctly. So the point, the strap line here is these changes are now with us. Some of them a wee bit delayed. And what has essentially happened is that two things. As of April, the government has introduced new immigration routes. So there's new language being used and new conditions, slight nuanced conditions compared to where we were previously. Some of the old jargon and terminology you would have heard will remain with us for some time, but is essentially gone. So the main aim for me today, hopefully, is for you to take away some better information about what the new categories might be, what the language refers to, and what that's generally about. So two main things have happened. 3 new routes have been opened up to immigration for business routes. And in addition, there have been some other changes, some nips and tucks here and there to some of the concepts that we already have and are familiar with. The 3 new routes are the so-called Global Business Mobility Access route, the High Potential Individual routes, and the route and the Scale-Up route. So those are the 3 broad categories. Now, it gets a wee bit more complicated than that, and I'll come on to explain why. Basically, for most purposes, the intra-company transfer routes that you may have used previously and heard about are effectively gone now, and there will be some crossover with some concepts and so on, which I'll come on to hopefully explain, but they're mostly gone, as are some of the other categories, and replaced to some extent by these 3 new routes. Now, these aren't the only routes, to be clear, they're additional, but they replace some of the former routes, particularly the ICT routes. There have been changes in a variety of areas. Now, I've said to Kevin already, I don't think we'll have time this morning with the short window we've got to go through these other changes, but I've listed them on the slide anyway, so that you can have a look at them and see a bit about what they're about. If we're doing fantastically well for time, I'll try to go through some of them, but as I say, I don't think we'll have time. We'll have questions after we go through the new categories, and then the rest of the detail is on the slides. If you have any questions arising from any of this morning, then I would encourage you to get in touch with your trusted Scottish engineering contact, see if they can help, and if they can't and you need further help, then if we can assist, then we'll be happy to do that. So coming on to the first new category, global business mobility. Now, I said it gets a wee bit more complicated, as legal things tend to do, and that's because there are 5 subcategories under the new global business mobility route. But essentially, this new route is for businesses seeking to establish a presence in the UK or transfer staff for specific purposes. It's envisaged that this will be used, or the first of these will be used where there's an existing presence in the UK. None of these routes will lead to settlement, so that's an important difference. For example, compared with the skilled worker route, which we still have, and that's subject to an English test. This, or at least the first of these, is not, but doesn't lead to settlement, whereas the skilled worker route can do. So the first of the subcategories is senior or specialist workers, and that applies where the requirement is to allow them to carry out carry out temporary work assignments in the UK, as I said already, where there's an existing trading UK presence, or including where there's an existing trading UK presence. There are various requirements. What I'm going to do with each of these new categories is go through the requirements and the permissions that you can get. So the requirements are, and you'll see this replicated through all of these 5 categories, a certificate of sponsorship from an A-rated sponsor. That must be issued not more than 3 months before the employer's application. There has to be payment of the so-called immigration health surcharge from the applicant, or on the applicant's behalf. That's £624. There's also a charge payable by a sponsor charge payable, I think it's £1,000 per annum per worker, per annum per worker, as well as that IHS payment. There has to be a score of 60 points. You'll remember, I think that I hope that we're now in a points-based system essentially. So there has to be 60 points across sponsorship, the salary being paid, 42,400 minimum, and a role assessment in accordance with a recognised qualifications framework, which you can find online. The applicant has to be employed on the application being made, and that has to be for 12 months cumulatively prior to the application going through, unless they're a high earner, and high earner, you will see mentioned a few times here, is just under £74,000 gross in the UK, 73,900. Now, what will that get the applicant? They can be permitted to work for up to 5 years or 14 days. Now, it's the shorter, in every case that I mentioned permissions, 5 years or 14 days after the end date specified for the work in the certificate. There's an absolute ceiling of 5 years maximum in any 6-year period, or 9 years out of any 10 for high earners, and time spent under some previous routes will count towards those maximums, and that includes if you already have permission under, for example, the intra-company transfer routes. In the main, that's what I'm referring to when I make that point, and that will feature on a few occasions. The second category is graduate trainees. We had something similar before, but there's a specific new category that falls under this GBM route, and that's for workers on graduate training courses regarding senior management or specialist positions who are required to carry out work placements in the UK. They need 60 points, again, through the same categories, but minimum salary level of £23,100 at present. Again, certificate from an A-rated sponsor. That confirms the graduate trainee has been working for firstly as a graduate trainee and working for the sponsor for 3 months at the application date, and that must be part of a structured training programme for a managerial or specialist role with the sponsor. And what will that get the applicants, then they've got a maximum of 1 year or 14 days after the end of the work date specified in the certificate, and again a total maximum of 5 years in any 6-year period, including any ICT periods that might count towards that. The third category is UK expansion workers. Now this largely replaces one of the old categories, which was representatives of overseas business, but for media representatives who are still subject to those old rules. There's a slight tweak being made there, which I mentioned before, and that's simply to say that there can be an extension and an application for settlement for those under existing permits here. But other than that, the category is essentially gone and replaced by this new category. So this is for senior managers and specialist employees who want to undertake temporary work expanding an overseas business, but not unlike the specialist category or senior category, not where there's a current UK trading presence, so it won't apply, where it won't be available where there is. The requirements there, again, a certificate from an A-rated sponsor. Again, same time period, that certificate cannot be issued more than 3 months prior to the application. There has to be payment on behalf or by the applicant of the immigration health surcharge, £624 at present. That varies actually if you've got dependents and depending how many there are, but for the individual making the prime applicant, that's £624. Again, 60 points need to be accumulated across the three criteria: sponsorship, minimum salary, in this case 42,400, and the role skill level assessed at a minimum level according to the qualifications framework. There is actually in all these categories a minimum level. I haven't set that out because I didn't want to be too technical for the purposes of this short chat today, but there is a minimum level, and that's according to a recognised framework, and you'll see what level it is if you ever have the need to look at that or want to look at that. There has to be cumulative employment for 12 months, again, unless in this case, unless the applicant is a high earner, just under 74,000, as I've said, currently with a slight exception for Japanese nationals according to a trading agreement that we have in place with them. So Japanese nationals, you need to be aware of that particular exception or particular arrangements. What will that get you? What will that get the applicant? The permissions will last for the shorter of 4 terms, essentially. Firstly, 1 year after the start date of the job specified in the certificate, or 14 days after the end of that job, in any event, for a maximum of 2 years permission as a UK expansion worker. So there's a maximum for which this will be permitted. You get to that point, you need to then look to transfer under to one of the other available routes, whether that's a GBM or skilled worker route or something like that. So you need to transfer. You want to continue. There has to be a maximum of 5 or 6 years cumulative under any of the GBM routes, though. So if you've transferred in from another, then there's a 5-year max of any 6-year period. Again, that can include previous permissions, previous ICT, that maximum previous ICT permissions. So if you're transferring over, there's a ceiling essentially. The fourth category, I think it's the fourth category, yeah, is service suppliers or contracting situations. So there was a previous category. This has now been replaced by this new one with slight differences. And this is where we want to bring contractors into the UK to carry out temporary work for overseas providers. There are some pretty stringent conditions under which that can be done. Firstly, same as before, a certificate from an A-rated sponsor. So I'm just checking time here. Firstly, a certificate from an A-rated sponsor. That again has to be issued not more than 3 months prior to the application. It must include payment of the immigration health surcharge, and there has to be an accumulation of 40 points. Slight difference here, 40 points across 2 categories. That's sponsorship and the role being assessed as option A or option B for service suppliers. I'll come on to explain what that means in a second. There are also, though I mentioned stringent requirements, the sponsor needs authority, firstly, to sponsor a service supplier from the Home Office, and the contract in question under which the work will be performed needs to be registered by the Home Office, firstly, and covered by a relevant trade agreement. Now, the skill level requirements, I mentioned there are two options, option A and option B. The first is option A, and that will mean the occupation and work is listed in an appendix of skilled occupation, and that triggers eligibility essentially. So that's option A. The alternative is that the work being carried out needs to involve a university degree or equivalent technical qualification, unless that technical qualification is excluded under the relevant rules. There has to be 3 years experience demonstrated as well. That's if the individual is being provided by a company essentially, or 6 if it's via a self-employed service provider. So what will that get you? A maximum of 12 months and a maximum length of any assignment of 5 years in any 6. Again, that may include that time, that maximum ceiling will include any previous transfers in from previous ICT routes, for example. The last new category is secondment workers, and that covers a wee bit of a misnomer perhaps, but it covers applications in cases of high value contracts or investments. There needs to be 40 points accumulated across 2 categories, sponsorship and the skill level assessment. There has to be permission for the sponsor to sponsor a secondment worker, again from the Home Office, and again the contract needs to be registered with the Home Office. That's the contract under which the seconded worker will work. The role being filled must be listed in a different appendix. That's the appendix for skilled workers, and therefore be eligible under the GBM routes. And again, there's a maximum duration of permission of 5 years in any 6-year period, which can include previous periods of transfer in from the intra-company transfer routes. So that's the GBM new category. As I said, that will largely replace the previous ICT routes that we had, generally in the senior and specialist case, and also specifically in relation to graduates. So the second new route is for high potential individuals, and that's for graduates of top global universities to come in. Tell you a bit more about that. Sorry, I thought I'd saved some more in my slide here. Bear with me. Yeah, so now that can be without a job offer, which is the first point. There's no need for a job offer in high potential individual cases. The graduation must be within 5 years prior to the application being made. The university needs to be listed on the global universities list, but there are no sponsorship requirements. So there's no sponsor involved here. It's just for those individuals graduating from these university. There's a minimum requirement for funds, but that's fairly basic. It's £1,270 held for 28 days. And there are minimum English speaking, English language requirements need to be met as well, unlike some of the other categories, for example, the specialist or senior workers. There are 2 options with the permissions for HPIs. If it's a bachelor's degree or a master's, the permission can last for 2 years. And if it's a PhD applicant, then you can be granted permission for up to 3 years. Now, that cannot lead to settlement, so that's an important point to note. There can be no settlement for HPIs, unfortunately, as with most of the new routes, and again, unlike skilled workers. Scale up is the last of the new categories, and that's for those who have a job offer from a qualifying scale up business. Now, what does that mean? Beg your pardon, seems to be a wee I've gone into the permissions first rather than the requirements. Apologies. So I'll deal with the requirements first. So what does scale up business mean? It means the business needs to demonstrate an annualized growth of a minimum of 20% of turnover of staff or staff for a 3-year period. It must have had 10 employees at the start of that 3-year period. The job offer needs to be at what UKVI would consider a graduate level and involve a minimum gross salary in the UK of 33k or the going rate if that's higher. In fact, all of these levels, when I talk about minimum salaries, it's always minimum salary of X or the going rate for that job if higher, and UKVI will specify in various lists that you can check online what the going rates are. Those have actually just been increased. One of the changes that's just been introduced as of April is that the going rates for skilled workers, for example, have been increased. So you need to check those lists. It's a bit of a immigration law is a bit of a moving feast. You're always checking the government's guidance and lists to see what you can and can't do. So that's the going rate if higher. Again, there has to be a certificate from a scale-up business that has to be issued within 3 months before the application. Again, there has to be a demonstration of a minimum maintenance of 1217 an account for 28 days, and there are minimum English requirements required for that is as well. Oh, sorry, I did have a slide with it's just out of sequence. Apologies, the HPI's detail is there just slightly out of sequence. I'll fix that when I send the slides through to Kevin. My apologies. Right, so scale up requirements we've covered. What does that get you? The permissions, well, initially this will be conditional on working in the role, but only for 6 months. After the applicant gets over the 6-month threshold, they can thereafter, they're not tied to that employer anymore. So they can go and make an unsponsored application for a 3-year extension. And once they get that, they can apply for settlement. You need to get to that stage first, so it won't automatically take you there, but they can apply after they've had 3 years in the role. Now that's both the extension application and the application for settlement are subject to demonstration of financial security, essentially, or maintenance minimums over certain periods of, not the full periods, I think it's about 50% and 2/3, depending on what part you're looking at, extension or settlement. So there are financial minimums in order for that to be done, as well as other residence requirements. Let me just check where we are time-wise. Yeah, I think we've got about 3 minutes. So these are the other, I'll mention this quickly. These are the other changes, the other areas that will be affected by changes. There'll be some nips and tucks with the EU settlement scheme, nothing groundbreaking, just to make you aware, but there'll be some slight tweaks in terms of when EEA nationals can support applications for family members without particular sickness insurance minimums being demonstrated. Been some tweaks to the global talent category in terms of overseas business reps, which I think I've touched upon already, in terms of existing members being able, existing applicants, sorry, being able to seek extension and possibly settlement thereafter. There've been some tweaks with Hong Kong, British nationals and innovators, and in relation to skilled workers, I mentioned that already. I think being that the main change being that the rates have been reviewed, so there are new going rates published. And lastly, there have been some tweaks in relation to students, essentially that students can work, I think, a bit earlier if they've made an application either for skilled worker, a skilled worker permit or a graduate permit. Then in either case, they can start work earlier. If it's a skilled worker application that they've made, they can begin work within 3 months of the course they're on ending. And if it's a graduate application that's been made, they can begin work as soon as their course comes to an end. So those are in really quick summary, the changes the main changes that are covered have been announced by the government in April in these other areas. Kevin, I think that leaves a wee bit of time for some questions, perhaps. Hope that wasn't too much of a brain dump.
It's certainly a complex topic, so thanks very much for breaking it down into those nuggets as you have done. So, folks, we've got 18 participants. Happy to open it up to questions just now. You either put it in the chat or verbally go just now. So, folks, over to yourself. A wall of silence. I think you're stunned.
I've just got one quick question, if that's possible. When you were talking there about graduates from high caliber universities, is there a definitive list of what they're classing as high caliber universities for that? There is, and it's the well, I can't. I'm not expecting you to go right through it.
It's on the global universities list, Chris. That's what it's called. So with all this stuff, anyone who's looked at the website will know there's a labyrinth of rules and lists, and it's not easy to navigate. But what you can go onto the UKVI website, I think it is, and you can find the list there and just search for it. If you should be able to drill down, as you know, graduates and so on.
No, that's fine.
There's a specified list which is recognised by this category, and it's called the Global Universities List.
That's fine. I know from previous experience you've gone onto said websites to drill down to lists that you think should be there, and you've been greeted with a big fat void of nothing, and then you have to call up wonderful people like yourself to help try and fill in the blank. So, no, that's great. Thank you very much for that.
Yep, you're welcome. No problem at all.
Cheers, Chris. Thanks very much for that. Any further questions at all? If not, I will thank John again. Thanks for the interesting presentation. And as I said, the recording and the slides will be sent out later on this week. And at that note, I'll let you all get back to your day job. Thanks very much, folks.
Thank you very much.
Thank you, everyone. Thank you, everyone.
Cheers, John. Take care, John. Bye-bye now.
Thank you.
Bye. Chris, if you're still with us, I will fix that little out of sync slide. Apologies for that. And before I send them over to you, so I'll do that now and send them straight over.
Cheers, John. Good man. Thanks very much.
Okay. Thanks, Chris. Thanks for the
Bye-bye.
invitation. Cheers. Bye. Work out.